Hi, folks. My name is Greg McLawsen. I'm the Affidavit of Support lawyer. I represent green card holders in federal lawsuits to enforce the Affidavit of Support, and I serve as a consulting expert when the Affidavit of Support is enforced in family law/divorce proceedings. Today, we're talking about enforcing the Affidavit of Support in the state of Texas. Texas is one of the states with the strongest and most clear law when it comes to enforcing the Affidavit of Support in divorce proceedings. The other one is probably the state of California, which has the Marriage of Kumar case, making it clear you can enforce the affidavit in divorce cases. But same thing in Texas. Texas actually has one of the oldest decisions in the family law context. That's the Marriage of Kumar case out of 2011. So for over a decade, it's actually been clear in the state of Texas that you can enforce the Affidavit of Support successfully in family court proceedings. It is also the case in Texas, as is the case in virtually every other federal jurisdiction in the United States, that you can enforce the Affidavit of Support in a federal action. So let's talk about the basics of rights under the Affidavit of Support and talk about those two options. So first of all, who has rights under the Affidavit of Support? Well, this is actually pretty clear. The Affidavit of Support is signed in virtually all cases where somebody gets a green card through a family member. So in cases of a spouse sponsored by another spouse, parental sponsorship by a child or a sibling, all of those cases in virtually all instances involve the Affidavit of Support. There's a limited carve out, a limited exception for somebody who has 10 years of work history in the United States. So I'm here in Seattle, Washington. We have a lot of tech workers. If you have somebody who's worked on an H-1B visa for 10 years, they might not need an Affidavit of Support. But that's really the limited exception. In almost all cases, if somebody got their green card through family sponsorship, we know with virtual certainty that the Affidavit of Support was signed. Now, the vast majority of cases where this is enforced are in situations where it's a spousal sponsorship or a fiancé visa. That's where you see the most litigation around this. And as we'll talk about in a moment, that's why this tends to come up in family law proceedings. But I also have clients who are, I have one in Texas right now, who is suing a child who failed to support them after they came to the United States. So again, anytime you have a family-based green card, that's a situation where the Affidavit of Support was almost always signed. The second component to figure out who has rights is that you have to have actually acquired status as a green card holder. So if you're in the midst of the process and haven't yet acquired your green card status, you don't have rights yet, because the rights that are owed to, the liability that's owed to an Affidavit of Support beneficiary, that starts when the beneficiary becomes a green card holder. So once the visa is granted and the person enters the United States or completes the adjustment of status process, once they have that green card that says resident since XYZ date, that's when the obligation starts. The third component, this is the final component of who has rights under the Affidavit of Support, is that the income level has to drop below 125% of the federal poverty guideline. Excuse me. Why? Because the right of the beneficiary is to have their income at or above 125% of the poverty guideline. Put conversely, the duty that's owed by the sponsor is to maintain the income of the beneficiary at 125% of the poverty guideline. So if income hasn't dropped below that amount, there's no legal duty that's owed to that individual. So when you think about what rights the potential claimant has, it's to recover damages equal to the difference between their actual income and 125% of the federal poverty guideline. Those are the damages that can be recovered in state or federal court. Again, difference between actual income and 125% of the poverty guideline. For a household of one in 2022, in the lower 48 states, that's $1,415 per month. Roughly $16,000 per year in the recent past. So that's how you determine initially who has a potential claim. Family sponsorship, acquired a green card, and income that has dipped below 125% of the federal poverty guideline. Now, typically, not always, but typically when people start thinking about, gosh, do I have a potential claim under the affidavit? It tends to be when a divorce is in process. Not always, but that's typically when we see this come up. One of the very common situations is that you have somebody who's come to the United States relatively recently, not a long-term marriage. In those situations, that person may not be looking at a very strong, very large, very long-term award when it comes to spousal alimony, because alimony, also called maintenance, tends to look at factors that include the length of the marriage, the relative financial strengths of the party, et cetera. But it's this multi-factor test, which is not the case with the affidavit of support. The affidavit of support simply asks, what's your income? Is your income zero? Okay, you are owed $1,415 per month. End of story. So it is a valuable right for somebody who has just come to the United States. Maybe they have limited work history. Oftentimes there are language disparities. And so this person is going into the divorce process and may be told by a family law attorney, look, you don't have prospects of long-term spousal maintenance, because when I look at the factors that exist, in this case under Texas law, it doesn't look to me like you have a viable case for long-term maintenance. But the affidavit of support does last a long time. The affidavit of support lasts until one of the 5 terminating events that are defined by federal regulations and recited in the affidavit of support. The 2 main ones are that the immigrant becomes a US citizen or has obtained or be credited with 40 quarters of work under the Social Security Act. And neither one of those things ever necessarily happens. So the duration of the affidavit of support is in fact indefinite. We don't know when it's going to end, because a sponsored immigrant doesn't have to become a US citizen and doesn't have to work. That's under the Leo v. Munn case out of the 7th Circuit. The person isn't becoming a citizen and isn't working, then that affidavit of support is not going to terminate. So that's a big difference in the family law context between a claimant who has potentially no or limited entitlement to spousal support under state law, but the affidavit of support exists, and that obligation goes on a very, very long time. That 2011 case out of Texas, the matter of Kamali case, specifically overturned a trial court level decision that limited the duration of support ordered in an affidavit of support case. So that judge had done what we see happen in a lot of family court proceedings, which is they're kind of stuck in this, the framework of family law that tends to disfavor long-term spousal maintenance awards and apply that thinking to the affidavit. Well, that's just totally inappropriate in the context of the affidavit of support, because Congress and the Immigration and Nationality Services, INS, now USCIS, has told us this isn't like alimony. And the events that terminate the contract are those 5 events in the contract and nothing else. So it's a mistake for a family law judge to arbitrarily limit the duration of support under the affidavit. So that's a 2011 case. There have been more than a half dozen appellate level decisions in Texas since then. Most of them are unpublished, but nonetheless, there's been a fair amount of litigation in Texas over this issue. I would say probably Texas is the state with the most family law litigation, followed by California and North Carolina. They both have a fair amount too. But this is a place where there's a pretty strong track record for saying that if you are a beneficiary of the affidavit and you're in family court proceedings, you are in a strong position to enforce the affidavit of support, and you should be able to get that ruling by the family court judge. And applying the matter of Kamali case, you should be able to remind that court very strongly that the duration of support under the affidavit can't be limited arbitrarily, or in other words, by terms other than the 5 terminating events under the I-864 contract. That is a very attractive option in terms of if you are a sponsored immigrant, you're thinking about enforcing the affidavit, you are in divorce proceedings already, Maybe you're already paying for a representation in that proceeding. That's great. Instead of thinking about whether you have to spin up additional separate civil litigation, you just bring the affidavit of support into the family court proceeding. The number one challenge that we see again and again is that not always, but very high probability chance, your family law attorney hasn't addressed this issue before. So when it's usually the client is the one who brings this up and says, hey, attorney, I think I might have a viable case under the affidavit, the attorney says, I've never heard of that. Can't really blame them necessarily. This is an immigration law thing, probably doesn't come up often in the family law attorney's practice. But the same thing is going to be true when it comes to the judge, that there's going to have to be a significant amount of education for the judge, who probably likewise hasn't seen this come up, certainly not often, and probably not ever in their judicial career. So that's often where it's helpful to bring in an outside expert to educate the local attorney, and more importantly, the judge, about how very much real these rights are under the affidavit and how they can be appropriately enforced in a family law proceeding. So number one take home is, yes, family court, Texas is a viable option for enforcing the affidavit. But you can also, as the affidavit of support plaintiff, that is the sponsored immigrant, you have the right to enforce your entitlement to support in federal court. So the Immigration and Nationality Act at 8 U.S.C. 1183A E1, almost got lost there, specifically creates a private right of action for that claimant to go to federal court. The affidavit has been litigated in over 150 cases all over the United States, including Texas. I'm currently litigating a couple in the Northern District of Texas, which is in Dallas. And the court there has been very appropriately willing to apply the statute and regulations in these cases very strictly. One of the wins that we had in our case in Dallas, one of our cases in Dallas, was what's called a preliminary injunction order. So in most litigation, you don't, as the plaintiff, get the relief you are seeking. In this case, we're talking about financial damages under the affidavit of support. You don't get that until the end of the litigation. That is how cases end, right? Usually, if you watch court TV, you think about a trial before a jury enters a verdict, and there's a judgment, right? Well, in federal court, those judgments might be a year or more from when a case gets started. The federal court system sometimes works very slowly, and going from start to finish in one of these cases can take a long time. Well, in the Sultana v. Hussein litigation in the Northern District of Texas out of Dallas, the court there was one of several in the United States that has granted a preliminary injunction. What that means is that you go in as the plaintiff to court and you say, Judge, we have an urgent situation here, and it's not good enough for us to wait for a year to assert our rights and hear that we have a judgment under the affidavit of support. We are a party who is reliant on the affidavit of support to meet our basic needs. And remember, that's the whole idea of the affidavit, is to maintain somebody at an income that's just really barely above the poverty guideline. This is not litigation between corporations. This is a right that exists to support somebody just above the poverty guideline. And the idea is to keep them from being dependent on public welfare programs. That's the idea. Sponsored rather than public welfare programs supports this individual. Well, that person can't wait around for 12 months or 2 years to get a judgment. They need support now. And the Northern District of Texas, very much to its credit, got that and said, we're not going to wait to go through all the litigation process. That has to happen also. But now, right away, the affidavit of support sponsor needs to comply with his obligation under the affidavit of support. And we are enjoining, so that's a legal word meaning we, the court, are ordering right now the defendant sponsor to come into compliance with their obligation under the affidavit of support. So that's terrific. That's a very important tool and sets, I think, important groundwork for future I-864 plaintiffs in Texas to come in right out of the gate and say, we are going to be entitled to our judgment down the line. That's for sure. but we are also right now entitled to an order telling that sponsor to get their act together and comply with the affidavit of support on a monthly basis while this litigation is continuing. It's called Pendente Lit Support. That's a Latin phrase. It means while the litigation is pending. So strong result there in Northern District of Texas. Federal courts are very consistently good about, we talked about that issue of sometimes family law courts end up muddying the waters somewhat by cross-pollinating between the I-864 obligation and family law principles. But you don't have that problem in federal court. A really good example of that is that federal courts have been holding consistently, most recently the Belovich decision out of the 11th Circuit Court of Appeals, that there are no defenses to liability under the affidavit of support. This is to say that the only way an affidavit of support sponsor can avoid liability in the federal court is to show that the affidavit has terminated. So in basic terms, unless the affidavit of support sponsor can say that the plaintiff has become a citizen or has 40 quarters of work, that affidavit of support is enforceable, it is still in place, and the liability is on the table. What affidavit of support sponsors want to do always is throw in this blizzard of scattershot defenses. So the common one is fraud. I was defrauded into this marriage. I was married only for a green card. If I had known that, I never would have entered into this marriage, and other procedural arguments. Even on their merits, by the way, those arguments always fail. So the courts that have gone on to consider arguments of fraud, without exception, always end up throwing out that defense, because the fact that a marriage doesn't work out doesn't mean that it was a fraud. But when you get into the actual factual weeds of those defenses, it takes up a lot of time. And again, this pushes out the length of time it takes to get a judgment. It increases the expense of litigation. And what federal courts have increasingly held is that no, those defenses just categorically do not apply in affidavit of support litigation, and we won't even hear about it. So that is another really important way that these claims are streamlined in federal court. So those are just two dramatic examples of why federal court can also be a really attractive forum. That preliminary injunction precedent, so the idea that you can get the court to order compliance with the affidavit of support even while the litigation is pending under the Sultana case, and the idea that there are no defenses to the affidavit of support. So we don't have to deal with this laundry list of every affirmative defense that the defense team can come up with from their first year law school contracts book. That's kind of what it seems like happens sometimes. The defense team goes through their contract law book from law school and pulls out every defense that they kind of vaguely remember having talked about in first year contract law. And the Belovich decision out of the 11th Circuit says, no, those contract law defenses just don't apply. We're not going to even hear about them. That affidavit of support, if it's signed and executed, it's enforceable, and the sponsor is on the hook until the person is a citizen or has another terminating event. So good options for claimants in Texas. Folks who are in divorce proceedings may find it most expedient to assert their claim in the divorce proceeding itself. That can be a great option. Just make sure that your family law attorney is capable, that understands what's at issue here, understands the law in the affidavit of support, and that they're bringing in an outside expert if they need it to make sure that they're able to properly brief and assert the issue in family law court. Federal court, also a great option. Strong precedent there in terms of the preliminary injunction rule, the absence of affirmative defenses, and a big plus, we have other videos on this, when it comes to federal court, is that there is a fee provision in the affidavit of support, which means that the sponsor is responsible for the costs and legal fees associated with enforcing the affidavit of support. So while in other contexts, it might be very challenging as a low-income individual to bring a separate federal court litigation to enforce the affidavit of support, in this context, the sponsor is actually responsible for paying those expenses of the federal court litigation. And again, that's the focus of my law practice, is representing plaintiffs in those federal court proceedings. So that means that both of these are a good option. If you're in family law court, you can potentially assert your rights there, get a judgment in the family law court. You can also bring separate federal litigation if you need to, and you don't have to worry in principle about the expenses of that because they are borne by the sponsor. So claimants in Texas, sponsored immigrants, green card holders who live in Texas should feel good about knowing they have two strong options available to them when it comes to enforcing the affidavit of support. If you are an attorney or a potential claimant who has general questions about this, feel free to drop into the comments. If you'd like individual advice, feel free to contact us on our website, and we do video consultations throughout the United States. Hope this is helpful, and take care.